Welcome back and welcome to Business and Immigration Law Updates. This is a proud presentation of Mr. Ramesh Khurana, who is the Chief Attorney and Counselor at Law at the well-known Khurana Law Firm, located in Gaithersubrg, Maryland. Today, Attorney Khurana will talk to us about the Wage and Hour Division of U.S. Department of Labor investigations of labor condition applications. Now that is a heavy-duty subject matter. Let's see our moderator, Attorney Kenneth Haber's questions to Attorney Khurana regarding this topic.
Hello, my name is Kenneth Haber. I'm a former Assistant United States Attorney and a former Senior Attorney in the Office of Investigations of the United States Department of Health and Human Services Office of Inspector General. I was there when we first started. And I'd like to welcome to the viewing audience to Ramesh Khurana. Ramesh is a literally internationally well-known immigration attorney who's helped numerous people across the country, across the world in his immigration issues, as we've had millions and millions of people come in since I was born, multi-millions, and people like Ramesh are the ones who help them process through a very complex system. This is the Capitol Forum, and you're here. Welcome, Ramesh.
Thank you so much, and I appreciate your kind introduction.
Well, it's truth, and it's from the bottom of my heart.
Really appreciate that.
Today we have some questions concerning the Department of Labor's investigation concerning the labor condition of application. Mm-hmm. What is the labor condition of application when you're talking about immigration?
Yeah. Ken, this is the underlying document based on which an H-1B petition is filed by the employer. So this is a very, very vital document because it would have, among other things, like what are the wages which have been decided by the employer to be paid to the employee. So they look at the prevailing wage and they look at the proffered wage. So if you say the prevailing wage is $60,000 and the offered wage is $80,000, so employer has got to pay $80,000 to this employee. And if the employer is not paying $80,000 to the employees per year, then the employee has got his right to file a complaint with the Wage and Hour Division of the Department of Labor. It doesn't cost this employee anything, no expense, even he doesn't have to spend a single dollar.
What protection does he have that he's not going to lose his job when he does that?
Well, of course, there are whistleblower laws as well, because if you are filing a complaint and you have not been paid, then Department of Labor, of course, first of all, they have to investigate the matter. And they want to make sure that this employee who has been unpaid or underpaid, that employee gets paid full wages as were provided as set forth in the labor condition application, which was certified by the Department of Labor. So they will say, these are the underpaid wages, you got to pay it. So Department of Labor would make a determination after the investigation. So once the determination is issued, now it is up to the employer whether they want to pay it or they want to go for an appeal.
I would assume, based upon earlier interview, that the employee would be able to stay there even if his job was terminated because of the investigation that he's caused.
Well, it will again depends upon a case-by-case basis. So nowadays, if a person loses his job, apart from the fact that he has got some issues with the employer and he is a victim of the circumstances, so the employee has 60 days, or when the authorized stay in terms of H-1B petition is expiring, whichever is the shorter, so he can try to find another job and move to another employer. Of course, the important thing is that he is to provide his pay stubs along with the petition, which is to be filed by the new employer. If he doesn't have the pay stubs for certain periods, then he has to prove that he is the victim of the circumstances and his employer has failed to pay him these wages. That's why it's recommended the employee has to document it fully. If he has really this kind of grievance against the previous employer, then he is to show some kind of correspondence with the employer that I was asking him for the payment to be made and my employer didn't make the payment, right. So, that kind of evidence, or in addition to that, if the employee chose to file a complaint with the wage and hour division, provide a copy of the wage and hour division when another petition is to be filed. So, that way you will just make an argument that this has been something which was completely beyond the control of the employee and he is the victim of the circumstances, then the gap or underpaid wages will not be held against him in terms of approval of H-1B petition.
Nice. Very
But
good.
there's a lot of work to be done.
Oh, yes.
By the attorney who is filing a new petition.
And they'll need a good attorney to do that because this sounds complicated.
Definitely.
How is an employer notified that there's investigation by the Department of Labor, DOL?
As soon as the decision is made by the wage and hour division of the Department of Labor that they want to investigate one particular employer, they would notify that employer. They may call that employer or they may just send out the letter or they may just go and visit the employer with the letter to be delivered by hand. So, they notify him that a complaint has been received and we have decided to investigate your company, and they will issue a letter and they will ask for certain documentation like payroll records and when the particular employee or if they have decided based on the previous negative record that they would like to investigate the whole company instead of just one employee. So, they may do so. So, they will say give us the payroll records. To begin with, they will usually ask for 1 year documentation unless they go back more than 1 year. So, then they will ask for start of the job and start of the wages. Sometimes most of the consulting companies, they would hire people, let's say starting from October 1, but salary is not paid for 2-3 months because they keep on searching for projects where these people can be placed. So, these kinds of beneficiaries are not paid for 2-3 months, but regulations are very clear that this is called benching as we discussed in one of the sessions. So, they have to pay irrespective of the fact whether that person is working on a project or not. They have to pay from day number 1. Otherwise, these are unpaid wages and the Department of Labor or wage and hour division will order the back wages to be paid. So, then I have seen in my practice they come to the office of the corporation which is being investigated and they sit down across the table and they have certain questions to be answered. They ask for documentation. Again, they analyze those documents. They may come back again and ask more questions or they will just issue the determination. Their decision is called the determination.
What are the obligations of the employer as far as continuing to pay the H-1B employee during this time frame?
Ken, the underlying document for the approval of H-1B petition is the LCA. So, LCA would control, LCA would disclose like what are the prevailing wages for that particular job and what are the pro-offered wages. So, the employer is responsible to pay the pro-offered wages. So, if the employer fails to pay, then of course, if a complaint is filed, if no complaint is filed, nothing happens. If a complaint is filed by the employee who is victimized, then Department of Labor can issue an order to pay those back wages. And if the employer really finds, in fact, this is a piece of advice to the employers who are watching this program. If the employer really finds that there is no project available for the employee, you should know that you cannot bench that particular employee, you have got to pay him. Better you terminate the services right away and then you are responsible up to the date of termination of the job. And when you are terminating the job for an H-1B employee, not only that you have to issue a termination letter to the employee, you have to also inform USCIS immediately about this termination. You should always do that. And other thing is, you should also offer the back home travel ticket. If a person has come from India, you say that we are offering you the air ticket to go back to your country. Unless these 3 steps are taken, there is no valid termination of the job. And I tell you, this is a very serious matter. Employers should know that. In that kind of situation, the Wage and Hour Division of the Department of Labor may order that your liability continues even though you took 1 step out of 3, because you haven't taken all the 3 steps.
So you terminated him, but you didn't give him his back pay, and
Back
you
pay,
haven't
yes.
given him a flight back home.
Let us say that person was terminated. He is sitting there here without any job, and he is not getting paid. Of course, he didn't find any job, and he doesn't have even to buy the air ticket, right? So he is sitting there. So if he files a complaint, and then this termination is not valid, so he may be allowed the wages even for the extended period.
What's the appeal process by the Department of Labor, by the employer, if he challenges the termination?
Yeah. Let us say that a determination has been issued by the Wage and Hour Division of the Department of Labor, which is against the employer. So this determination indicates that you have got to pay the back wages to the employee, and these wages are sometimes even hundreds of $1,000s if the company as a whole has been investigated. Now, employer in this kind of situation may choose to file an appeal. This is called the request for consideration, and this request or appeal process starts by filing a complaint. These are called claims and counterclaims. So you file your claims with the administrative law judge of the Department of Labor. As you are aware, all these federal agencies, they have their administrative law judges. So as an employer, you file your complaint, and then the matter is litigated before the administrative law judge.
And is there any appeal to U.S. District Court from the administrative law judge, or is there an appellate bank there?
From the administrative law judge, it goes to the next level again, but this is within the process. And unless you can show there was some abuse of power or authority, but I tell you one thing, people get tired up to this stage. People get tired because they do not want to go beyond that stage. Department of Labor has got really exceeding powers. They can even issue citations, they can issue civil penalties, they can even issue criminal penalties. You might have read in the paper recently, so many people have been prosecuted because if they were committing certain frauds willingly. So if somebody is doing anything knowingly and willingly, and you are basically defrauding the system, then you are rendering yourself liable not only for civil penalties, which may include that you are barred from filing further labor condition applications. If you are barred from filing more labor condition application, that means you cannot even file the H-1B petitions, or people have been imprisoned if they have been committing frauds. So this is a very serious situation, Ken.
Sounds that way, and I'm sure that people who are viewing us right now realize it's pretty serious, and they know that if they ever get in situations such as these, they need to get a very good attorney.
That's right. It's very, very important. And moreover, you want to keep your all employees happy, and you want to pay their wages.
Yes.
Why to abuse the system?
Absolutely. Well, I'd like to thank you for coming on in and helping our viewing audience have a better understanding of these complicated issues.
Thank you, Ken. Appreciate.
Our pleasure.
Yeah.